All right, I'm going to start this up because it's 3:16 now, which is going to try to get us moving and try to keep us going here. This is guardianship, conservatorship, and other legal documents, a guide for parents with a child or adult with special needs, something that we try to do on a regular basis. I am Tom Alessi. I'm one of your presenters. I will introduce my partner, Craig Richardson, in a second. Before I start up, though, I do want to do a little bit of housekeeping. First, a big thank you to Alex and Sandy over at Riverside Community Care for one, putting this all together, but two, for having the tenacity to stay with it. We were originally going to do this live back on St. Patrick's Day for you. Obviously, COVID-19 sort of waylaid those plans, but Alex and Sandy stayed with it and said, let's try to do this virtually. And so here we are today. So a big thank you to the two of them. I do want to say, second, apologies in advance if there are any technical difficulties that do pop up. You know, we're all in this sort of ever adapting, ever changing world. One of the things for us is this is a new software provider for our webinars. I know a lot of you probably have used Zoom, and we do use Zoom for our individual meetings, but as you may have heard, Zoom's run into some technical issues. One, everybody's crushing to use that, but the other is that there's been some security breaches, and when we scheduled this, they hadn't tightened up their security, which they did. So just in case, I want to say if you do get run into or have any technical issues, we are going to be sending an email out to all of you in the next day or two, which will have a recording of this, which hopefully if there were any issues, they won't be in the recording if they happened on the connection side for you. So you'll be able to view this or pull it back up and play through it at ease. When we do send that out to you, one of the things that we always ask for any attendees is input and feedback. So we do want to make sure that we're going to send you out an evaluation form that if you would take a second just to go through it, send it back to us. Just it helps us with collaboration because we do a lot of these presentations. And third, and more importantly, you're muted throughout the whole event. That's just the way this webinar software works. There is a chat box, so if you do have questions, if we can get to them, we will try to answer them. If we can't, what we'll do is when we send out the recording in the email, we will put the list of questions in and have the answers that go along with it. But if we can, we'll try to get to them by the end of this. See, I've run into technical issues already. No, there we go. This is just a disclaimer. It's something that I have to say because compliance and legal makes me do it. So I'm not going to really read through it because that doesn't do us any good. You will be getting a copy of it, so you can certainly just play it or take a look at it when you get that and see it. Who we are, just a little bit about the Moody Street Group real quick because we don't like to spend a lot of time talking about ourselves. We're a boutique financial services firm in Newton. About 8 years ago, we decided to dedicate a portion of the firm to what is now known as the Special Needs Resource Network. The goal of the Special Needs Resource Network is to help and support a family with a child or an adult who is differently abled or has a disability. The mission of the Special Needs Resource Network is to do this. I mean, literally exactly what we're doing today, which is to connect as many organizations, advocates, and other professionals that we can to be the support network for those families that we work with. This is a little bit about us. I'm the guy on the right. That's Tom. Craig, who I will introduce in a second or two. In a couple of minutes, he'll come in and begin the presentation for us. We really don't like to spend time talking about us. We do a lot of these workshops. Last year we did over 30 of them. This year we were tracking towards doing probably 40 to 50 of these educational and informational workshops throughout the year. Obviously, COVID-19 waylaid those plans as well, but generally we do them live and in person. So when we're standing in front of the room, we don't have to talk about ourselves, but we do want to give you a little information and detail As you can see, between the two of us, we've got almost 40 years of financial services experience. More importantly, both Craig and I, our family, we've had family members who have been touched by special needs. And it's the reason right now the two of us are actually guiding, we're responsible for the Special Needs Resource Network here at the Moody Street Group. Get that, make sure that that's working. It's a little quote we like. You've developed the strength of a draft horse while holding on to the delicacy of a daffodil. You are the mother, advocate, and protector of a child with a disability. Lori Bergman, that's just a quote from her. It's one of the things we like to include as part of anytime we're doing these presentations. So what we're going to talk about today, and that is what are the steps that you should be consider taking, or what you should be looking at or reviewing or going through as far as either guardianship or conservatorship. So Craig is going to, and I'll turn it over to him in a second or two, going to talk about sort of the standard documents. Understand that some of this is real basic, but we're not sure ever of who's in the audience. So we just want to make sure we cover all the bases as we go through this, where he'll talk about the will and a durable power of attorney, a letter of intent, and then he'll turn it over back to me, where I'll go through some of the ins and outs of guardianship as well as conservatorship. I do have one thing I do want to add before I bring Craig in. I got a quick poll. I'm praying that this this is technology for you. Here we go. All right, so it's a quick poll. Hopefully you can see this on your screen. It just says, what is the biggest concern you're hearing about right now? Right, so if you can take a couple of seconds here and just click which, getting supportive supplies, learning and educational development, activities while somebody's at home, or helping them get their affairs in order. So if you've thought about it, or if you've been out talking to people or had conversations, please take a second, try to fill that out. Not seeing the poll, Sandy, thank you very much. Of course, that didn't work. I appreciate it. I tried. See, like I said, technology doesn't always work for me. But thank you, Sandy, for letting me know that. All right, so what I'm going to do now is I'm going to turn it over to Craig. And Craig, just let me know when you want to move forward as you go forward. All right? Okay?
Okay. Well, let's talk about wills. So a will is probably the most important legal instrument you can have drafted during your lifetime. Generally, a will is a document prepared in accordance with legal requirements in which you can specify how your assets should be distributed after death. When making a will, however, remember that not all assets are controlled by a will. Joint property with rights of survivorship, for example, pass independently of a will. Similarly, the life insurance and qualified plan benefits are paid out of the named beneficiary without regard to the will. So what that means is that you need, not only is it important to make sure that everything in the will is spelled out, but also when you're looking at your retirement accounts, your life insurance, you need to make sure that those beneficiaries not only have a primary beneficiary, but just in case that primary beneficiary should predecease you, make sure you have a contingent beneficiary on there as well. Tom and I have been dealing with some cases lately where they weren't named, and it creates all kinds of problems from a legal perspective. Next, please. So without a will, the law controls who gets your assets. So the state distributes your assets according to its intestacy plan. It names who will take care of your children, even a special needs child, without regard to your wishes, and it does not worry about how much or how little you pay in estate taxes. So without a will, once again, if you move to the next slide. Next, please.
Yep.
State intestacy laws may leave assets outright to your special needs child, and that could jeopardize their eligibility for government benefits. Also, without a will, the state will determine guardianship of a minor child and any special needs adult who is incapable of making medical or financial decisions for themselves. So a properly written will in conjunction with other estate preservation documents can help ensure that a special needs child is taken care of properly according to your wishes and instructions. The other issue you have to consider too is without a will, the judge is going to decide who gets custody of your children or that adult. and they're going to have 15 minutes in a family court to hear people back and forth to decide what's going to happen to your children. So there really is no, if you, whether you have a special needs child or not, it's extremely important to have a will in place to talk about guardianship. And we'll get into that later as we go along. Next slide, please. Okay, so next thing is going to be talking about general power of durable power of attorney. That is where you give another person the power to manage your financial affairs and property, even if you become incapacitated. Now, the other thing you have to remember today too is that husbands and wives, it's all or couples, regardless, it's very important for them to also have a durable power of attorney because you cannot just sign for your significant other or spouse, even if you are legally married. You have to have a general power of attorney. So the general power of attorney is a written document that gives another person the power to manage the financial affairs and property of another person, even if you should become incapacitated. So it allows the agent or attorney, in fact, the right to act the same extent that you could act if you were present and able to act. The rules vary slightly among the different states, and there are some restrictions. For example, an agent or an attorney, in fact, cannot perform fiduciary acts. They can't vote for you in an election, and they also cannot change your will. Can you move forward, please? Next slide. So general durable power of attorney is broadly drafted. It may include the power to make gifts on your behalf or split gifts between an incompetent you and your competent spouse. A broadly drafted EPO may include the power to make gifts. So the gift giving must be clearly authorized by the durable power of attorney itself or under the applicable state durable power of law. If a special needs trust has been created and funded with life insurance, the agent or attorney, in fact, will be able to continue gifting premium payments if necessary into the trust while you're incapacitated. Then you have to remember, though, is a durable power of attorney does not go past your death. So once you pass away, the durable power of attorney goes away. Next slide, please. Thank you. Durable power of attorney for healthcare. So this is solely created for making healthcare decisions, gives your agent the power to make medical decisions when you can't, and takes effect once your doctor determines the lack of capacity for you to make your own decisions. So, like I said, if you're in a position where you're in a coma or you're in a position where you're on a ventilator or something along those lines, and you cannot make your own financial decisions, it's very important to have somebody that you trust who does have that healthcare proxy and in place, so that you don't have to try to guess what that your wishes are going to be, or even for their wishes. Next, please. So there are some steps that are unique for the special needs preparation, such as drafting a letter of intent, which we'll go over in a minute, ensuring guardianship, and providing financial security. So as a parent of a special needs child, you've learned that in general you have to do more for a special needs child than parents of non-special needs children have to do. Estate preservation for a family with special needs child is no different. There are extra steps that you should consider taking to provide for their future, including, said, the letter of intent. Next slide, please. Thank you. So the letter of intent is not a legal document. Okay, it's a guide filled with important information about your special needs child. Go to the next slide, please. Thank you. So the letter of intent is going to actually tell the story about your child's biographical and medical history, your wishes regarding living arrangements, education, religion, your child's personal likes and dislikes. So basically, this is something you want to keep up with. And with special needs child, we always know they have different rituals. They have different things that make them happy, things that make them sad. So you want to provide them with your child's favorite colors, nighttime rituals, religious preferences, favorite foods, special education or vocational arrangements, who they like to hang out with, what games they like to play, what things calm them down, what things rev them up. So once again, this is a letter of intent is there not just in case you pass away, but even if you had to go away, say, on vacation for a while and you were leaving your child in someone else's care, they'd have a roadmap, if you will, of how to deal with your child when you're not there. So once again, very important, and it's also important to make sure that this is up to date. And next slide, please. And this just basically just goes over again what we just talked about. Talking about daily likes and your routines, likes and dislikes, who their friends are, social life, their spiritual life, favorite recreation and leisure activities, um, case managers, doctors, dentists, therapists, who the barber is. That could be a very big deal, especially today. No one has a barber right now. Legal and financial information, location of pertinent documents. So this may actually spell out, is there a trust? Who is the trustee? Who's the attorney that you're working with? Who's the financial advisor you're working with? So it's just, like I said, a roadmap. So if you're not there to talk for your child, there's something else there that will give them all the information that's needed. And that would bring us back around to guardianship, which would bring us to Tom. So
Thanks, Greg. So one of the things with this, and like I said in the beginning, we did want to cover some of that just as part of this. Again, it's sort of putting the foundation in place to make sure having the will, we haven't talked about special needs trust, and we really won't get into it in this presentation. But having the will, the power of attorney, certainly, and when I get to the end of this, I'm going to talk about a timeline and sort of wrapping that all together, because these are building blocks. These are pieces that really should be in place for everybody, whether we're dealing with a family with just a typical child, or a combination, or even just having a single special needs child. These are pieces that should be in place for everyone. All right, so guardianship, right? And this is a quote that's from Michael Gregorio, and we think it sums it up really, what guardianship is all about. And that is that guardianship is the only way I can make sure that his mom or I will be able to advocate for what is necessary so he will be safe and happy. To secure this, I must prove to a court that my son is incapable of making decisions on his own. My wife and I must also choose someone to accept this responsibility when we are no longer alive, and who we can trust to carry out our wishes. And that really, for us, summarizes exactly what the guardianship mission is all about. Now, guardianship from a definition standpoint really is that it just means you as an individual have an invested interest. You've got a lawfully granted power, or charged with the duty to oversee or take care of a person who is incapable of administrating or taking care of their own affairs. Now, that's really what guardianship comes down to. If you think about it, the parents of a minor child are considered natural guardians. The child can't make the decision for themselves, so parents are automatically granted that guardianship. Guardianship, however, in this case and what we're talking about, really is only dealing with the person. That's what we're talking about, is over an individual, over a person who is involved. All right, so once the child reaches age of majority, which is really what this is all about, right, they become their own legal guardians. And well, again, at the end, I'm going to talk a little bit about a timeline for all of this. And they become their own guardians regardless of their own ability to manage their lives or their financial affairs. They're really, there's no choice. They're their own guardians at that point. If your child is incapable of making a medical or financial decision, that's where the conversation question comes into about, do I need to have guardianship, or more importantly, should I be filing for guardianship and dealing with it? So we do have a couple of questions that come up, and maybe you've gotten some of these or responded to some. And so we've just sort of, that's how we put this together. And the first one is, do I need a lawyer? Right? Do I need somebody to help me in terms of obtaining guardianship, to retain or not to retain, right? Well, there's a lot that's involved. Let's put it that way. You've got medical records, you've got legal documents. All of this stuff has to be put together when you go to file for the petition for appointment. It's a process. There's a lot involved, and it can take anywhere. It's a minimum of at least 6 months. Can take anywhere up to a year before that can happen. And trying to get all of that together can be very, very stressful, especially on a parent trying to do all of that. But the bottom line is, can you do it? Can you go out there and file and obtain guardianship on your own? Yes, absolutely. You can do it all by yourself. More to the point, or actually the question really should be, should you be doing it all by yourself? And that's where Craig and I really, we tend to lean towards the answer of no, right? The idea is that there is counsel that is available that you can tap into or use to help you in the process. You don't necessarily have to be all in. You can parcel this out, right? There's actually what is known as LAR, which is just, it literally stands for Limited Assistance Representation, which says you may only want an attorney to help you with the legal documents. You'll take care of all the medical stuff and get that all filed and done, but you don't need help with that. So you can actually set up an agreement, this limited assistance, to file for that. You can go out and find an attorney who's going to do it for, and most of them will, a flat fee arrangement, i.e., I'm going to help you with guardianship and obtaining guardianship, and it's going to be, this amount, and that's it, right, as far as the cost is. But one of the things we suggest to everybody is to just go out and have a conversation. Most attorneys, especially in the special needs community, are going to talk to you and not charge you for that sit down or for that initial conversation about what you're trying to do. It gives you an opportunity to ask questions, get some information, get a little bit of feedback on what it is I need to do or what it is I'm trying to put together. And that's the idea about what's going to help you, become somewhat of an educated person in this process. So the next question is, really, and we sort of touched on it a little bit. I know Craig mentioned it and I just went through it. What is guardianship and where do I file this petition for appointment? Right? Well, the guardianship just refers to, as I said before, the child becoming their own legal guardian. So age of majority. So once they become 18, they're their own legal guardian, right? If you don't believe that your child can handle their own medical or financial or take care of themselves, then what you need to do is you need to file for guardianship, right? That guardianship is filed in the probate court. That's where that is handled. It's family and probate court. As Craig said, that's where that happens. And you go from there, and I just had a technical issue, so I'm going to apologize. I will try to get us back on track here with that. I'm not sure what happened or why, but see, I knew there would be a reason there. Okay, I'm back. Sorry about that. I don't know what happened there. I went in and out. Right, but so one of the pieces with this is that you can, when you are filing for guardianship, right, it doesn't necessarily mean that you have to file for full guardianship. You can file for partial or only having to handle a certain area. Maybe it's medical condition. Maybe the child's just not able to handle the medical ins and outs or dealing with their own health, and you can file a petition for as being a guardian to help with that part. And that's as far as the limited portion of that. But again, you've got to file that in family court. And as Craig said, that's who's going to handle this out if there's no will in place to deal with all of this. All right, I am considering a guardianship for my special needs teen. At what age should I begin the process? Craig and I get this all the time. And as I just said to you earlier, the process takes anywhere from 6 months to a year. So we're going to say that certainly by the time the child reaches age 17, and you'll see this when I get into the timeline, the conversation or outline or assessment should have been made that the child is either going to be okay on their own or there is going to be a need for some sort of oversight, some sort of care. We're going to either need full guardianship or a limited guardianship for this child. And we should, at minimum, begin that process at the latest, I should say it that way, at age 17, because of how long it's going to take. a lot of times Craig and I will recommend usually about 15 or 16 for that, to start that process, just to make sure it's being put in place. But at the absolute, you know, latest age would be age 17 to begin that process for doing it. All right, so what are my responsibilities as the adult child's guardian, right? So again, depends on what type of guardianship you applied for. If you applied for full guardianship, that means you're making decisions on everything. That's medical, personal, all of the decisions. Limited guardianship, that's only based on what you have applied for, whether that's medical, personal decisions, right? And that usually then gets outlined as responsibilities by the court. The judge will decree that and make an order of guardianship. And then every year, a care plan has to be filed that goes along with that to say this is what is being done, and there's been no changes to the care going from there. We'll talk about a Rogers guardian in a second, a definition on that. That's something that does come up, and being appointed as a Rogers monitor, but that's something a little bit more detailed and involved than what we're talking about right now. And so really what happens is that you have to have this order of guardianship and then file every year the annual guardianship care plan that goes along with it. And that's what's necessary to handle from that side of dealing with everything. I do have some definitions for you, some of the forms, right? The medical certificate, that's just something that needs to be completed. The physician, a licensed psychologist, certified psychiatric nurse, clinical specialist. That needs to be done within 30 days from when the petition is filed. So if the petition has been filed, that medical certificate needs to be completed within 30 days. The petition for appointment of guardian for an incapacitated person, you've got two different options inside there, as I talked about before, which is full guardianship, in which case you're checking a box and explaining why you need full guardianship, or why you're requesting limited powers, why that's appropriate, and what those are. And then you've got to have a follow-up with that, an additional document that explains what those limited powers of guardianship apply to and how they will be used. The third one on there is a bond. This is basically you're agreeing by becoming a guardian that you are going to follow the decree. You are going to be held to what the court or what the judge has put down. And so you are issued a bond in order dealing with that. Now, most bonds, when done, have what are known as a surety that goes along with them. That's usually you're putting down either funds or collateral to put the bond in place. In the case of where we're dealing with a guardianship, the usual course of action is to request a waiver. Just ask to have it waived. They usually don't hold you to anything with that, and you can just go forward and have that waiver applied and do not have to put any collateral up to have the bond. The clinical team report, right? So this is dealing with intellectual disability. This needs to be done, physician, licensed psychologist, the social worker, and it must be written within 180 days from when that petition is filed. When we get into Rogers Authority, and that's what I was talking about a little bit, that's where we're dealing with antipsychotic medications, and that's usually there's a court order that goes along with that. With the Rogers Authority, a lot of times, most of the time, I will say that, I'm not going to ever say 100% for anything, but a lawyer will be appointed by the court to help with that. There's, findings in a treatment plan that go along with it, and definitely an annual review of that Rogers monitor needs to be done along with it. So that's part of the decree that comes from the court when you're dealing with it, as far as dealing on a Rogers monitor. I'm going to segue over to conservatorship just quickly, and the difference really is that, and there's a lot of words on the screen, so I got to apologize, but I didn't want to break it up into multiple screens on you with this, but this is when we're talking about the person who is unable to act on their own behalf when dealing with property, right? You are being appointed to help them out, and you'll notice the wording on there is ward. That's just how an individual is referred to by the state. So don't worry on the ward wording inside there. But the right to make, modify, or terminate contracts. You can see the right to buy, sell, otherwise dispose of property. All of the actions that go along with it. Similar, and a lot of times, if somebody needs guardianship, they will be conservatorship will be done at the same time, but really that only applies to somebody who has assets or somebody who is going to be earning other than Social Security or any income that's provided through the Social Security Administration. As far as Social Security is concerned, there's that process is called the Representative Payee Program, and that's done where Social Security Administration will handle that. They'll handle all of the part of going through that. A conservator basically owes the individual. Really, it's just like the fiduciary responsibility. You've got to act in a prudent manner. You've got to be responsible. It's with reasonable care, diligence, and you are trying to do everything that is the best interest of the individual and their property, right? You should always take into consideration whatever the individual is asking when you've made conservatorship and you are dealing with it. You can, if somebody, if an individual is looking to purchase a vehicle, let's say, just to use it as an example, it's one thing to get them a Toyota Corolla. It's another if they want, a Tesla. So there's limitations in terms of what actually can be done. But as a conservator, you can actually act on behalf of and not deny, but certainly make recommendations and act on their behalf to help them out with that. Same rules apply as far as annual filings. That is, that a conservator must, on an annual basis, show any of the proceeds, any of the distributions, any of the funds that were spent on behalf, why, and show an action plan and what occurred with that, sort of an accounting and overview to any of the funds that have been spent for that period of time. All right, so I told you that we'd have this is a basic guideline, so don't take this as, hey, works for everybody, but just talks about different ages, timeline, and things to be considering when we're looking at it. Right, so like I said, age 13, and this is really between 13 and 16, if you see the blocks, to be thinking about, the individual, the child's trajectory, where do we see them going, how are we going to, as parents, set up and handle their living, supplementing any of their income needs when we're not around to help. Right, so that's where the special needs trust comes in, some of the funding options and arrangements that go along with that. 16, we get into, a transition plan, post-secondary goals, what's the path that they're going on, updates to any IEPs. At 17, start looking at different healthcare providers, because we'll get into that in a second. But then this is the guardianship, right? And now one of the notes on there says, at a minimum, you should have a durable power of attorney, will, and a healthcare proxy completed. And I say this to everybody. If you have a child who's going away to college, it makes sense to have a durable power of attorney on that child, because there's no way that you can act on their behalf if something happens to them at college and they, for some reason, can't act on their behalf. You have no say in that. As a durable power of attorney, you would have the ability to at least be involved in there. So it's something to consider, not just in the special needs world, but in every child that's going away, where you have the ability to at least act on their behalf. 18, they become age of majority, right? So now you're applying for adult SSI, considering, and you can just see it, postponing the graduation, right, to consider additional transition services. 19, out of children's Medicaid, apply for adult health or keep them on your plan. At that point, put them on your plan. 18 to 22, that's vocational training opportunities, whether it's post-secondary education, whether it's vocational training, whatever the case may be, you're looking at the pathway from 18 to 22. And then at age 26, obviously all children opt off or are no longer allowed to stay on parents' health care from that point. So it sort of gives you the timeline from 13 to 26, looking at transitions and some of the guidelines that goes along with that. For our conversation, this is really about age 17 on the block. We'd prefer it to be a little bit earlier, but those are the things that should be in place. The decision, a conversation should have already been reached about guardianship. And then there absolutely should be a durable power of attorney in place for any child that's going away, regardless of whether their special needs are typical. Let's see here. Final thoughts for us with this. Create or update the letter of intent. That, as Craig was going through, really is one of the most important things to stress to parents. I think the letter of intent, even though it's not a legal document, should be included and treated as almost though it is a legal document, and should definitely not only be curated but updated on a regular basis. Put together the timeline, sort of what I just went through with you for transitioning, or what the path looks like, or you think it'll be. Decide about guardianship prior to age 17. How many times I'm going to stress that and go through it, but that is absolutely the number there. At a minimum, I just went off on a soapbox there a little bit with the durable power of attorney, but it's something I absolutely believe in and stress to everybody to do and to have, but definitely should be put in place. And then consider a special needs trust, right? Because all of this is going to be what happens later on, not, just 4 or 5 or 7 years, or like the timeline 13 years, but what happens when the child's 30 or 35? Maybe you're no longer in the picture. You need to be thinking about funding options and what you're going to do at that point. All right, so this is Craig and I and more of our fun moments here. This is a little bit about us. For those of you who have seen us around or maybe know us a little bit or seen us at any of the conferences, whether, MDSC or SPAN or the Federation for Children, we're usually in our Patriots jerseys. We do a lot of these presentations in those Patriots jerseys. We have a lot of fun with it. We give out Patriots jerseys. It's sort of our way of giving back, having a little fun. In this case, our winner from last year was Bethany. I don't know what Bethany's going to do right now, because you'll notice those are Tom Brady jerseys. She is Brady's, as she said, #1 fan. One of the things is we will be sending, as I said to you in the beginning, it's an evaluation form that will go along with the recording that we sent out. We value the feedback that we get from every attendee. Try to stay on topic, stay on point, see how this went. So please, when we send it to you, we're going to ask you to do us a favor, send it back. We just use that to make sure that the topic and information that we're sharing is relevant and topical for everybody who's involved. We offer a consultation. As you don't have to do, I just put this in. It's in every presentation that we do. But if you ever have any questions on anything, you want to meet with us or sit down with us, we do it just like the attorneys. There's no charge for that. We don't charge anybody to sit down and have questions and go over anything. And a lot of times with parents, what we're trying to do is help them sort of gather everything together so that they can get a handle on all the information that they have, so that when they go and meet with that special needs attorney, they've got it all together. Because otherwise, they're going to spend half the time with the attorney trying to answer all the questions and figure out where everything is to build out that blueprint and try to figure out. So we do that as sort of a way to help them, and then also give them some of the questions and some of the things they might be asking or should be thinking about when sitting down with that special needs attorney.
You have a question there, Tom,
I do.
from Karen.
Okay.
Does a parent need to do a durable power of attorney if they have full guardianship?
No. Thank you, Craig. I didn't see that. I don't see that question. I don't know why,
Okay.
but that's okay. But I appreciate it. Yeah, no, I mean, if you want to follow up and answer that, go ahead.
No, I would say the same thing. No, it's really just redundant if you have full guardianship. So but you can always, ask your attorney as you're going through the guardianship process. Can a parent petition for guardianship later in the child's life if at 17 the child is still amenable to the parent making decisions for them? The answer to that is you can always petition for guardianship later. The issue is once they hit the age of 18 and they're considered a legal adult, the requirements to show why they are not capable of making their own decisions becomes more difficult.
Right.
Because they can always say that no, I'm fine. They can argue it. So.
And it's harder to get, sorry, just on that, Sandy, it's harder to get that full guardianship, right? Because limited is, if you're only going for limited, yes, when you're after 18, it's a little bit easier, but full guardianship becomes much harder too, as Craig was saying, because you've got to show all these different pieces to it and all of the ramifications. Now, some of them, it may be the case anyway, but it's just a much harder road to go down versus doing it at 17. Anybody else with any questions? If you think of them, feel free. You can always shoot it to us. Like I said, what we're going to do is we're going to send you this out. I know some of the people might have had some problems with the volume. As I said in the beginning, there were some technical issues. We do apologize, but hopefully the recording will have everything for you, so you'll be able to see all that, and we'll have it so it's a little bit tighter and better as far as going through it. So, but other than that. That is. Anyway, I want to say thank you to all of you. Like I said, what you're going to get from us in the next day or two will be a copy of this. We'll have a copy of the recording. So as you go through it, if you think of anything, if there are any questions, we're also going to include the evaluation form along with that, and we would really appreciate that you get those back to us. If there's ever anything we can do, if you know an organization that could benefit from something similar, we've got a variety of topics that we deal with as far as doing these educational and information, whether it's special needs trust, whether it's the ABLE account. That's another big one that everybody has some questions and concerns on. We're happy to help out in that situation. So Alex just let me know she was having problems. No, Alex, I wasn't sure if you wanted to say anything. I was giving you a second to do that, but that's okay. All right, so I want to say thank you, everybody. Certainly appreciate it. And we did get a last-minute question as I was closing that up. Where did my channel? Oh, I thought I had a question. Technology is not my friend right now. So anyway, thank you, everybody. I'm going to close it up. Have a great rest of your day, and please be safe out there.
Yes, stay safe.